All right, we are on the record in State versus Bryan Kohberger, CR 0124-31665. The state is represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. The defense is represented by Ms. Taylor and Ms. Massoth. The defendant has been excused from appearing. The defendant himself has been excused from appearing today. With us also are petitioners, counsel representing petitioners, Ms. Olson and Mr. Pedersen. Today's hearing was set to address the interested parties' petition to be heard as interested parties related to the court's closure of a portion of the hearing set for Thursday and Friday. So with that, I will let, whether it's, I'm not sure if Ms. Olson or Mr. Peterson is addressing the court today, but whomever is may address the court.
Thank you, Your Honor. It will be Ms. Olson on behalf of the interested parties who are various media organizations and professional journalist organizations with a history of covering the proceedings in this case. And the interested parties thank the court for this opportunity to address this issue regarding press and public access to the hearings that are scheduled to start tomorrow at 9 a.m. Your Honor, as the court knows, the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public and the press to attend criminal proceedings. And while few cases in Idaho have dealt directly with public access to pretrial proceedings, and in particular suppression hearings, at the federal level, both the United States Supreme Court in Waller versus Georgia and the Ninth Circuit in Associated Press versus U.S. District Court for the Central District of California and in United States versus Brooklier have addressed the issue. Waller did so in the Sixth Amendment context. Brooklier found that the First Amendment right of access extends to suppression hearings, and in Associated Press, the Ninth Circuit extended the logic in Brooklier to pretrial filings, writing in the very first part of its opinion, there is no reason to distinguish between pretrial proceedings and the documents filed in regard to them. Notably, both Associated Press and Brooklier involved high publicity, highly public defendants and charges. Associated Press involved federal narcotics charges against, among others, John DeLorean, and the Brooklier case involved a RICO prosecution against members of the criminal enterprise La Cosa Nostra. Waller, in particular, in its decision, sets out the benefits that the U.S. Supreme Court has seen in its various decisions that arise from public proceedings in criminal cases. It notes that in Gannett, a case in which the United States Supreme Court looked at but did not decide the issue of press access to suppression hearings, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. And in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, a public trial and public proceedings encourage witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, a court must afford those excluded from the proceeding a reasonable opportunity to state their objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirements set out in Press Enterprise 2 before it can close those proceedings. A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings need to be sufficient in writings, insufficient so that a party excluded can challenge them. The Ninth Circuit has explained that a court cannot be closed in criminal proceedings unless such closure serves a public interest. There's a substantial probability that in the absence of closure, this compelling interest would be harmed, and that there are no alternatives to closure that would adequately protect the compelling interest. And that's in Oregonian at 920 F. 2nd at 1466, quoting from the Press Enterprise 2 test. Here, Your Honor, the interest parties are not arguing for a blanket order opening the court. We are arguing for the court to adhere to this long-established process of determining how and under what circumstances a court could be closed for a hearing. For many of the media outlets we represent, even in national security, child sex assault, and organized crime cases that they cover, the process that we are seeking has been carefully followed. The public and the media have a right to appeal unwarranted closures of a courtroom, but they're unable to determine whether the court is being closed appropriately because the court so far has not made public the most basic information regarding the reasons for its closure. The defendant in this case, in both its January 13th and January 21st filings, seeks an open hearing and asserts that an open hearing is of utmost importance to him. Therefore, any concerns about the closure being required to ensure the defendant's right to a fair trial are moot. And as Mr. Kohberger pointed out in his motion to hold an open hearing, the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced. The burden is on the party seeking closure. That's from Oregonian 920 F. 2nd at 1467 and Brooklier 685 F. 2nd at 1167. As we understand it, Your Honor, the interest being advanced by the state is concern for information being provided to the potential jury pool and possible inadmissible evidence being discussed in open court. But that is inherent, Your Honor, in any motion to suppress hearing. The whole basis of the hearing is to see whether the evidence should be excluded or admitted at trial. Concern about the public maybe learning about this evidence, and even if it ends up being inadmissible, is therefore not an overriding interest. And absent that some evidence that this discussion that would occur in the hearing would taint a jury pool or provide information that would be difficult to seat a jury, I think that is also not sufficient evidence for this court to find that it's a compelling interest and warrant closure of the hearing over both Mr. Kohberger's objection and then the right of public access. It also appears from Mr. Kohberger's filing yesterday that the state asserted that Mr. Kohberger's acquiescence to the non-dissemination order is somehow a basis for them to argue that Mr. Kohberger cannot now object to this closure. Not certain if that was the argument that the state advanced, because we haven't seen their pleading. It's not on the cases of interest website. But as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in-court proceedings are precisely the kind of information that should be available to the public as this case moves forward. Your Honor, I would submit also that there is tremendous public interest and it serves a tremendous public good for the public to know at the time that it's being considered the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Kohberger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case. What is more, without IGG, this case would never have been brought against Mr. Kohberger. The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal. The court in Waller, when it was talking about the aims and interests of a public trial, noted that those aims and interests are no less pressing in a hearing to suppress evidence. And then they pointed again to several of the individual opinions in Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to suppression hearings, but they didn't reach that question. In Gannett, the comments that many of those justices made was that in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty or the evidence was suppressed and no case went forward. And similar reasoning supported press access to preliminary hearings in one of the few Idaho cases to address access to pretrial hearings, and that was the Cowles case. In Cowles, the Idaho Supreme Court noted that the process in conducting preliminary hearings in Idaho is likewise sufficiently like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing, a court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary. An actual Franks hearing, in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly, and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Franks hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer, swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life and liberty of an accused, whether that law enforcement officer did in fact tell the truth or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual. Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IGG evidence is the identity of perhaps family members of Mr. Kohberger, I would submit that there are two alternatives at least that might address that. One is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. I would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person one or person two, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Kohberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients whose records may be at issue in a case, and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings, and those individuals are often identified, for example, by a random number or by a Medicaid identifier number, and not by their name. So their names are never revealed in the course of the proceedings. And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Kohberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media. Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on Ms. Olson's argument that was not previously presented?
I would like to make a record on behalf of the defense.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
I don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm not sure what you're referring to, so I apologize.
So we had discussed that the evidentiary hearing portion of it for the IGG would be closed.
Correct.
But that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks. The Franks proffer, with the exception that there will be, in the proffer, there will be a need to talk about specific names and in particular names of some lay witnesses in directing the court to the 1,000 pages that were submitted under seal in relation to the proffer.
All right. Well, with respect to the names, I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the initials.
Okay, we can do that.
Anything from the state, Mr. Thompson?
Not for me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
Mr. Nye?
No, Your Honor, nothing beyond what was said yesterday. Thank you.
All right. Well, I appreciate the presentation today. I will note this case is a little bit of an unusual posture in that there was previously a non-dissemination order issued in this case in which it was clear the tract of the court and at the time the parties was to avoid given the media scrutiny the potential for impacting the jury pool that exists here with evidence that may ultimately not exist and evidence that may not ultimately be admissible. That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. That's exactly why it's not open. We will be challenged under the best of circumstances, of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to, and I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential impact on a jury pool. In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions, motions in limine, and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. As I talked with the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike. And is that for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible. I have not and will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach, which is easy to do by simply going offline for a minute. And that's what I intend to do. Tomorrow, in particular, the evidence with respect to the IGG, I think at this point it's appropriate to, and I will issue an order shortly, to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Frank's hearing as it relates to IGG in a closed environment. I think we can decide at that time before we go online whether we can have the IGG portion of the Frank's proffer publicly. The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Frank's and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up, about the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case, we can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using, then I can follow along. And I think that's the better way to proceed so that we can do as much of this in open light as possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly as was offered to me. That doesn't give me comfort, to be frank. But for the meantime, until we can, I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible, and anyone who hears about it may therefore be removed from the jury panel, I think it's better that we proceed in this fashion for now.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. In our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood Judge's the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows if the defense, if there is a statement that is made, under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order following today's hearing. I don't think that what you said accurately reflects my understanding of the defense's position yesterday, but I appreciate that. I do understand Judge's prior order to be dealing with extrajudicial statements because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with Judge's ruling at that time. I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. So, at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right, so I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence, I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that that be produced. But in the meantime, I think I need to take this course, so I appreciate that. Thank you.
Thank you, Your Honor.